Hello, everyone. Welcome to the Dialexicon podcast, where we critically engage in philosophy and correlate philosophy research to contemporary issues at an easy to understand and digestible level. My name is Saurish and I'm your host. And today we have with us Dr. Georgi Gardiner, who is an assistant professor in the Department of Philosophy at the University of Tennessee and was previously the Andrew Fraser Junior Research Fellow at Oxford University. This year, she was awarded the Chancellor's Notable Woman Award from the University of Tennessee. Her work is broadly focused on epistemology and metaphilosophy. Hi, Dr. Gardner. How are you today?
Oh, good. Yeah, feeling good. Thank you so much for having me. I'm really delighted to be here with this podcast.
Of course. Thank you so much for your time and for being here today. Before we begin our discussion, although I did just kind of briefly go over your CV, for our audience that may not know a lot about you, could you please provide a little bit more information on who you are, your background, your relationship to philosophy, and what philosophy means to you and how you kind of got involved in it?
Sure, yeah. Well, maybe I'll start with the last one. How did I get into philosophy? So I'm from Britain, and in Britain, you apply to university, you apply to the subject, and it's pretty much the only subject you study. So you don't take a range of courses and then declare a major. You just like go there to study philosophy or maths or whatever it is. And in high school, I just really didn't want to narrow down. Like I wanted to keep a breadth of subjects as much as I could. And in Britain, we narrowed down really fast, really early. But I wanted to keep doing maths and the sciences, but I also wanted to do sociology and economics and also the humanities, history and literature. I really didn't want to narrow down. And I thought philosophy would be a good way of not narrowing down. And I was right. And I'm so glad that I kind of had that thought because I didn't really know what philosophy was, as most high school students, don't. But philosophy is really broad because you can do sort of logic and you can do the foundations of maths and you can do the philosophy of history or economics and you can also do philosophy of science and what interpretation of physics. And then you can all do all kinds of things, literature. And so it really is a nice way to avoid narrowing down. And I guess I also always just ask these questions that were like philosophical questions, so just always kind of the kinds of questions like about God and why is it something rather than nothing, and about why be good, why be ethical, and so on. So I was just always really drawn to philosophy questions before I started at university. One thing I tell my students is that philosophy has this very distinctive feature, which makes it a good one to study, which is that it's inescapable. So what I mean by that is like, if it's something like learning history or economics or physics or chemistry, you can just be like, I'm just not gonna form any chemistry beliefs. I'm just not going to form any economics beliefs. I'm just not going to learn any history, read any literature. You can do that. It'll be a mistake. Be like you're sort of failing to enrich your life and maybe failing to sort of do your duty to learn like history as a citizen or something. But you can do it, it's possible. Whereas philosophy is not like that. It's like if you say, I'm never going to learn any philosophy, you're already doing philosophy by sort of figuring out you have to know what philosophy is, so to avoid it. Or, oh, philosophy is all bunk, it's all useless. Or no one ever makes any progress in philosophy, so it's not worth doing. You're already doing philosophy. And then also if you just think, what should I do? Why should I do it? Who should I be? What traits should I have? What's worth it caring about? You're already doing philosophy. So it has this like deep inescapability. And so given that, I figure that it makes sense to sort of at least learn to do, to do it well, as opposed to really poorly, given that you have to do it. And I think there's one other, as a quick side note, I think there's one other subject that has that kind of inescapability, or one other thing, and that's politics. Like you can't opt out of politics. So even to opt out of politics is itself a political stance. So philosophy and politics have this inescapability to them. So that's kind of how I got into philosophy. And as for what my own work is, I mean, in a certain sense, this ties together what I was talking about, it's being broad and inescapable, is my own research kind of runs a gauntlet from very abstract to, how to model epistemic value, epistemology, fancy pants word for theory of knowledge, but like knowledge, rationality, belief, justification, evidence. What is the nature? So I do this abstract stuff. What's the nature of understanding? What's the structure of epistemic virtue? And what's good about epistemic value? Should we model statistical inference in science? All the way to these really applied subjects. So the most recent essay that I've just been writing is, how do we know that we're in love? Like why do we think we know what love is? And our judgments about whether we're in love, like what makes them good ones or bad ones? Or similarly with queer and sexually attracted and so on, like in virtue of what do we know that we're queer, and what makes us think that we sort of know what attraction is and what love is and so on. And then self-deception about things like rape. So when people are raped and then they are in denial about that, what explains that? Or like if other harmful or costly beliefs like my child is an alcoholic, or I don't like my job, or I'm bad at my job. When people are in denial about those, how can we explain that? And some work on how do we conceptualize self-harm and sex work and all these kinds of really applied topics. But most of what I do is in the middle of those two extremes. Most of what I do is somewhere between the really applied and the really abstract. And that's kind of what we're going to be talking about today, because legal epistemology is, I mean, it can be done in various ways, but the way that I do it is really in the middle. It's applied, it's epistemology applied to these sort of social institutions and social phenomenon.
That's really interesting, especially kind of like the story of like learning philosophy. I had I interviewed like another Dr. Simon Brown, who's also from Britain, and so he had also had like a similar way where he got interested into philosophy and then chose philosophy. And I don't know, I think he was saying like they're called A levels, I think, or like some sort of test or something like that in Britain. And so like that's an interesting story, because like in the United States we don't have that limiting. We kind of have the luxury of like whenever we go into college we have a luxury of classes that we were allowed to take, and we're allowed to move around in majors and in a lot of colleges. And so it's interesting to think that like philosophy was the route towards doing that in an area where you're so trapped almost in kind of determining what you have to do for your future. So like that's an interesting way to think about philosophy, because philosophy is quite literally inescapable. By thinking you can escape it, that's philosophy. Like you have to know philosophy in order to even say those things. And definitely we're going to get into a lot of your research and kind of like that middle ground you're talking about the abstract on one far end, and then the applied on the other far end. So we're going to get into the middle of that. But before we do that, I do want to clarify some definitions with you, because we did mention that epistemology is like a fancy word for kind of theory of knowledge. But what exactly is legal epistemology, and what questions is that field attempting to explore, and what is evidence in the context of legal epistemology? Because when we're talking about law and just the legal field in general, evidence is something that's always mentioned, right? It's you have to have evidence in order to kind of plead your case or literally do anything in terms of in legal field. So what exactly does that mean in that field?
Yeah, great. So good, important question. So what is legal epistemology? It's a really kind of flourishing, kind of exploding topic right now. Like very few people did it a few years ago, and now a lot of people do it. And so basically it's looking at the intersection of law and epistemology. So epistemology is evidence, rationality, justification, when a belief's good ones. And the kind of legal cases that typically are the kind of contexts that are looked at in legal epistemology tend to be trials, legal trials. So civil trials, criminal trials, so finding somebody criminally culpable or suing somebody. There's other questions as well about police conduct and how should inquiries occur. But that's sort of in juries. And so the kinds of questions that are looked at in legal epistemology is things like, what are legal standards of proof? So the most well-known legal standards of proof is beyond reasonable doubt, is used in a lot of jurisdictions for criminal conviction. And preponderance of the evidence is a lower one used for civil cases. So what are they? Like, what do they mean? What does it mean to say the preponderance of the evidence? So that's one big question in legal epistemology. What kinds of evidence and reasons are allowed if we're, say, trying somebody? And this relates to your question, well, what is evidence? Like, you have to show the evidence. What is that? And so evidence basically is like what bears on the truth of a proposition. So if is it raining outside? Well, what's your evidence? Is the things that will make it such that you should believe that it's raining outside. So make it more likely that it's raining outside. So having a look and seeing that, or somebody coming in with an umbrella is evidence that it's raining outside, especially if the umbrella is wet. But in law, what matters is the admissible evidence. So you can have all kinds of evidence that bears on the person's guilt or innocence, but it's never heard Partly maybe because they never found it. So like there is a witness and they really are reliable and trustworthy, but they're deceased or they're in hiding or they're an accomplice, so they don't want to say. And so there's really good evidence, but it just never comes to light. There's also evidence that's inadmissible. And so suppose it was evidence found in a illegal search or evidence found under torture, then that might be the kind of evidence, or it's hearsay evidence. So evidence of somebody told somebody who told somebody, but that person, the original person is not there in court to be cross-examined. That's hearsay evidence. Those things are not admissible. So even if the lawyers know the evidence, they're not allowed to bring it up. And in fact, if it is brought up, the jury has to sort of pretend they don't know it, sort of try to isolate it off, partition it off, and make their judgment based on something else. And so also there could be fairly conclusive evidence reported in the newspapers. But if that was inadmissible for some reason, then the jury is supposed to be able to say whether or not just the case brought in front of them with the admissible evidence in court reaches that threshold of the preponderance of the evidence. And so what kind of evidence is inadmissible? Oh, and notice, by the way, and we'll come back to this, I think, is that it's not sort of, does the evidence mean that they're probably guilty or 100%? It's meeting that particular threshold, that beyond a reasonable doubt threshold. So what kinds of evidence are allowed and not allowed? Well, so there are these exclusion laws. Federal rules of evidence in the US articulates these exclusion rules. So one, for example, is character evidence. So evidence that the person has committed prior crimes is typically not admissible. It's admissible in some contexts. And so legal epistemology will ask, well, is that kosher? Like, is there something wrong with not allowing that? Because suppose that the person is being tried for burglary and they've committed loads of other burglaries in the past. Well, doesn't that mean that it's more likely that they committed this burglary? And so typically that evidence wouldn't be allowed unless it's allowed to show, is permitted to show something like they knew how to do that particular kind of complex, dual theft or something like that. So legal epistemology will look at can there be epistemic reasons? So there might be moral reasons or political reasons or pragmatic reasons to not allow that. It's just not fair to try this person based on, and let the jury sort of be biased by the fact that they've done all these other crimes. Because the jury might think, well, whether or not they did this one, they deserve prison time because of all the other ones. But legal epistemology can also ask, well, is it epistemically rational? Are there actually good epistemic reasons, truth-relevant reasons? Like maybe the other evidence that they've committed all these other crimes, even if it's evidence that they committed this one, the juries will overestimate that. So that it does make it more likely they committed that burglary, but the jury will think, well, of course they must have committed that burglary as well. And so they overestimate the probative value of the evidence, the epistemic force of the evidence. So legal epistemology asks questions about profiling. So questions like, given that the defendant is a member of a demographic group, can that be used as evidence against them? So is the fact the defendant is male evidence that they committed the violent crime, for example? And then sort of what is the presumption of innocence, and questions about the whole structure of the legal system. So should we have an adversarial system where two lawyers duke it out, one against the other one, two legal teams like we have in America? Or should it be more inquisitorial, like they have in some European jurisdictions, where the judge is the fact finder? So they do all the investigating and they decide. And similar questions about things like expert witnesses. What kinds of expert witnesses should we allow? Well, the ones who are just providing, say, the science behind some evidence, like explaining DNA evidence or explaining fingerprint evidence. Well, what kinds of evidence and what kinds of experts and which experts should be permitted? Because what if it was astrology evidence? Well, we might not want astrology evidence, for example, but why? So that's a collection of the kinds of questions that legal epistemology will investigate.
Okay, that's really, really interesting. And, kind of while you were saying all of this, I was just thinking in the back of my mind of the Johnny Depp trial right now that's going on and kind of taking over the news in general. Like, for example, you were talking about hearsay, right? That's there's been so many videos of the lawyers talking about hearsay, and I don't think a lot of people actually know what it means. We're just kind of I say we, but like most people, and like at least in the comments and stuff, are just kind of laughing at the way in which it's said so frequently in these cases. So yeah, that's like definitely like a really, broad field. Like there's a lot of things to explore here, and like I'm sure like I could probably be captivated like in just one section, like exploring just like maybe like the epistemology of like juries, like which is like a question that we'll explore later. But definitely like a lot of cool questions to ask here. But I'm interested kind of in the way that your answers, or at least your work in your kind of your theories or whatever is conducted. So you mentioned previously that you're looking mostly at like trials, right? But is it a lot of analysis of different cases that have all like maybe in like way in the past and trying to correlate those to epistemology, or is it always looking at different, maybe like looking at the current events that are going on with like let's say the Johnny Depp trial and analyzing that through an epistemic lens and how like the legal teams are taking those through like kind of a theory of knowledge, like picking up evidence or like punishment or race or confession or paradoxes that are present in specific cases that are going on right now, and then correlating that to epistemology. How does it necessarily work for you in your research?
Yeah, great. So most of the most common pattern in legal epistemology is that there'll be some insight or debate or question in epistemology that then has bearing in the legal context. So an example is this lottery paradox. So I know that a very recent guest you had is Liz Jackson, and she was talking about belief and credence. And so the lottery paradox came up, which is great. So the lottery paradox is something like you have an absolutely, it doesn't even have to be massive for this example, but like a big lottery, loads of tickets. And then you have one ticket and you think, well, my ticket won't win because what are the chances? And so maybe you even throw it away before you get the results, or you assert to somebody, I didn't win the lottery. I won't win the lottery. And it seems like there's something wrong with that, something strange about that. But that's a little bit puzzling to explain why, because given the evidence you have, the base rates, the fact that there's so many tickets and you just have the one ticket, it's exceedingly likely that it's true. Like really, probably you won't win the lottery. And so the lottery paradox is basically explaining why it is some kinds of evidence seem to make it really probable that your belief is true, and yet aren't the kind of thing that can justify certain actions, like throwing the ticket away or asserting my ticket didn't win. You need some other kind of evidence, like checking the results. And it's a paradox because some of the other kinds of evidence, like assertion, like somebody telling you, oh, these are the results, then you can know on those grounds that your ticket didn't win. But they might actually be more likely to be misleading. Like it could well be that in that case, they told you the wrong numbers, they misremembered or something. But nonetheless, it's the kind of thing you can know based on. So that's the lottery paradox. Okay, well, that kind of evidence seems to have some bearing or some application. So that kind of debate has some application in legal cases. Why? Well, these like legal standards of proof, for example. So beyond reasonable doubt and preponderance of the evidence, what do they mean? Well, so preponderance of the evidence is usually glossed, almost always glossed as more likely than not. And in Britain, it's known as balance of the probabilities. That sounds a lot like at least 50% likely, like more than 50-50, more than a coin flip. And so it really invites this quantificational analysis, like this understanding of what legal standards of proof are, or at least preponderance of the evidence, as a number on the line between like 0 and 1, between 0 and 100 if you're doing percent chance, where preponderance of the evidence is 50, and then beyond reasonable doubt is really high, like maybe 95%, something like that, 90, 95%, maybe 99%. And then some other legal standards of proof like clear and convincing evidence, they're often glossed, they're in between preponderance of the evidence and beyond reasonable doubt. So they're often glossed as like 70, 75%. And then there's lower ones like probable cause and reasonable suspicion, which govern police conduct. And then they say, well, they're even lower. They're like 20% or something. And maybe we'll get to this, but I actually don't think they're proof standards at all. I think they're epistemic standards in the law, but I don't think they're standards of proof. And I think it's a mistake to call it that. So, okay, that's like the quantificational analysis of legal standards of proof. It has some, now we remember that lottery paradox. So we can create a kind of lottery paradox for legal standards of proof. How? Well, suppose that there's an event venue with a gig on, so a band on stage, and that they don't have a ticketing system or it stops working. And so people just start gate crashing. They just start entering. And suppose there's a 100 people in the crowd, and we know that 65 of them gate crashed. Well, now, if we pick some random person, preponderance of the evidence is that they gate crashed because 65 out of 100 of them gate crashed, so more than half gate crashed. So it seems like just that evidence of knowing that they were in the crowd and that 65% of the crowd gate crashed means that you know of any arbitrary person based just on that evidence that they've preponderance of the evidence. You know that they probably gate crashed. If the preponderance of the evidence just means given the evidence available, probably P, and that means that evidence satisfies that legal standard of proof, preponderance of the evidence. And so now the event venue the owners of the event venue can now take any particular individual to court and sort of sue them for gate crashing. And there are similar cases like that where somebody's hit by a bus and they can't tell, or say a taxi, and they can't tell the color of the taxi, but there's only 2 taxi companies in town, red taxi company and green taxi company. And then 60% of the taxis are operated by the red taxi company and the other 40% are by the blue taxi company. So then can the woman who was hit by the taxi just say, well, it was the red taxi company because there's more red taxis. So that's another kind of example of a proof paradox kind of example. So now we can take all the insights that happened over decades of epistemology talking about the lottery paradox and say, well, now how does this apply to legal standards of proof? In what way are legal standards of proof similar or different from the epistemic thresholds governing whether we know that our ticket didn't win, whether we can throw out a ticket, whether we can assert that our ticket didn't win, and so on. So that's one kind of example where it's a very common example of how we can take a debate in epistemology and then transfer it to the law. Similarly, when I was talking about character evidence earlier, character comes up in philosophy because there are these debates about, well, are characters stable? Are characters really good predictors of behavior? And that has a bearing on virtue theory in ethics. A lot of those debates can then be transferred over to the legal case about character evidence law. So that's a very common pattern, is the taking a debate in philosophy, in epistemology, and then seeing how it illuminates these debates in law. But it's a mutual illumination, because now by doing some work about the legal case, we can now begin to better understand the epistemic debates, the more abstract epistemic debates. And then the other way around, the other thing that you mentioned is, well, do you ever look at the actual legal cases and start there? I think it's less common, but I think, yes, especially the more looking at very specific legal cases is less common. But for example, it does happen. And for example, in a recent paper, I found a case where there was, it seems like a fictional case, but it really is true. The identical twins, there was identical twins, and one of them committed a series of stranger rapes, and DNA evidence was at the scene. And they did the DNA test. And so based on the DNA test, the police were extremely confident that it was one of the 2 identical twins. But at the time, no DNA test could distinguish identical twins based on DNA of the relevant kind. They can now, some tests, not only one test, I think, but there's a question about whether that test is admissible, actually, because even if the test exists as science, there's a question about whether it's admissible evidence, because you need to have enough trust in the science for it to then count as admissible. But at the time, the test wasn't even developed. So the police knew that it was the crime was committed by one of 2 identical twins, but they didn't know which one, and they didn't have any other evidence. And so they didn't arrest either twin, saying, well, we don't have any corroborating evidence, so we can't arrest. And then what happened was an accomplice who was also one of the people committing the rape was arrested later. And as part of his plea bargain, he said, yeah, this is the person who did it. It was this brother, not the other brother. And so then they arrested the guy. And eventually he was found guilty. But I look at that case and I say, well, hang on a minute. Is it really, were the police actually correct that they need corroborating evidence in order to issue an arrest? Given that arrest is governed by probable cause, then does do we need corroborating evidence to have like reasonable suspicion and probable cause? And I look at that question and I say no. And the reason, and then the answer to sort of why I say no is, what is the nature of corroborating evidence and what is the nature of reasonable suspicion and probable cause? And I say they're not actually proof standards, so you don't even need corroborating evidence. Even if you need corroborating evidence for legal proof, which is an open question, but even if you do, reasonable suspicion and probable cause actually aren't standards of proof. They're not proving anything. They're just saying you need evidence of a certain kind or quality, but that's very different from making a verdict. Whereas all the other things are legal standards of proof. They're verdicts about how the world is, even if they're quite low, like preponderance of the evidence. It's still saying probably the world is like this. Reasonable suspicion is just, it's about the quality of the evidence you have. Is your suspicion a reasonable one? So that's an example of how you can start with a real life case to try to illuminate the nature of, in this case, probable cause and corroborating evidence.
So that's really interesting, because now you have like kind of like both ways, and I guess this is a common like theme throughout philosophy, is that philosophy and whatever field you're applying it to, they work like they work together, right? And you know, I've heard from basically everyone I've ever interviewed, and they're all like, yeah, we like philosophy aids maybe like the sciences or whatever field they're looking at, but the sciences also aid philosophy in certain research. So like I guess the biggest example could probably be like consciousness research, using like neural activity to kind of guide how consciousness research in the philosophical field is working, right, compared to like how it's working in like the neurobiological field, right? So it's really interesting to see that's also the case here in legal epistemology, and I guess I might just conclude to myself that it's in every field for philosophy at this point. And so yeah, that's definitely interesting, and also kind of doing the reverse logic where you start from one and then go to the other. It seems that maybe it's more frequent to start from epistemological view and then apply it to something to kind of gauge your understanding of the epistemological assumption you're making or whatever you're exploring. But obviously it's also possible vice versa. So that's interesting to explore as well. But I'm also kind of curious now, like we've talked about how both of these things work together, and you know, both of them can happen in both different ways, like i.e. going from epistemological to the legal, and then also going vice versa. But how does your work get handled in legal, like in the legal areas, right? If we've come to this conclusion, does it get like used, or like, I mean, I want to actually probably refrain from using conclusions given that it's philosophy, but you know, like whatever your work is, like, is it used in conferences or in like real legal changes to kind of change laws or like how legal battles operate? Like, what is the kind of like scope of the work that you're doing? Because I've heard from a lot of people that, you know, or a lot of philosophers, that philosophers should be taken more like, you know, hardly and like strictly into more consideration. Do you feel like that's the same thing in this field at all?
Yeah, I think it really deeply has applications. Like, I think it's a really valuable area of philosophy for that reason, because it can really have these effects. So that example that I just used of the police not arresting, I mean, if my theory is correct, it's really showing like why the police were incorrect, that they need corroborating evidence to arrest. And so if police genuinely believe that they need corroborating evidence to arrest, then this work can be like, it could affect police training to explain, like, no, you really only need one piece of evidence. The single piece of evidence can do it, can justify an arrest. It might be worth noting, though, in that case, that maybe the police would have arrested the suspect if they actually wanted to or cared to, because it was really strong evidence. But I don't know. I mean, it was kind of strange, right? Because one of the ones they knew was innocent and one they didn't. One they knew was guilty, and one they knew was innocent. They just didn't know which way around. But yeah, so I mean, these kinds of cases, like explaining to police officers proving to police officers why they don't need corroborating evidence to arrest, can have real ramifications. I think the closest I've come to so far to that kind of thing is I met with lawmakers in New York to talk about rape, sort of how to secure more convictions in cases of rape, because it's very hard to prove rape. I mean, it very often comes down to these she said, he said cases, and there's a lot of doubt about those, a lot of misunderstanding about those. And so they were asking about how they might be able to change laws. And one thing that I was sort of saying, because they were talking about, could we change make some change to the legal standard of proof in operation. And I was saying that's a really big, ambitious change. And there might be these other things that could be done instead, like having people better educated about rape myths. So rape myths are things that are widely held, like widely believed, but that aren't true about rape. And a lot of them seed doubt about rape accusations. And so things like, well, if it was real, if it was really rape, she would have reported it sooner, or she wouldn't have been nice to him afterwards. She wouldn't have been friendly to him afterwards, or she would have been like noticeably upset, or she would currently look different. Like she would currently be behaving differently, like she would be upset in the witness stand or something like that, looking upset in the witness stand. And so these kinds of things are rape myths, and they're pernicious because they can seed doubt. So then the jurors, or in everyday life, ordinary people, will think, well, then it wasn't rape, because if it was rape, she would have acted differently. And so a lot of my own work is tackling those rape myths, saying like, here's why these things, this kind of conduct, this kind of behavior, these kind of patterns aren't actually evidence against a rape occurring. So to the lawmakers in New York, one thing that they could do to try to secure more convictions for rape is to have programs in place to try to undermine those rape myths. So perhaps some training for the jurors and so on. I think those kinds of things. And that wouldn't take too much change, in the sense that wouldn't be some big overhaul of what kinds of evidence is admissible or what kinds of legal standards of proof govern the case. It's just what kinds of, implementations are there for undermining rape myths in the jurors and the judges and the lawyers, for that matter, and legal training. So that's a kind of example. And another place that my work is quite applied is I'm currently an ACLS fellow, American Council for Learned Societies, on a project that's looking at what standard of proof should govern Title IX cases. So complaints of sexual misconduct in colleges and universities in the US. Should it be governed by the preponderance of the evidence, that kind of relatively low standard, or some higher standard like clear and convincing evidence? And I look at sort of what kinds of evidence satisfy those cases, and what kinds of evidence do we want to be the kind of evidence that somebody could be expelled or fired on. So it's a very applied context.
Okay, that's really, really interesting. Like kind of like two fields, right? And like the second half of it, like the latter part was about like the universities. I mean, that's a direct field in which I can kind of see how like this would play out. I guess there'd be like kind of a lot of different, I guess maybe like cases for how high you want to set that threshold, and then each one would have probably its pros and cons and kind of looking at different scenarios. But I'm curious about like this, what happened like in New York. Did they come to you, or like did you have to reach out to like them, or did they had they read your research or something like that? I'm curious kind of about that.
Yeah, it was through Hi-Fi Nation, which is a really lovely philosophy podcast. So your listeners might also be interested in it. And it's, do you know Hi-Fi Nation? Yeah. It's a very popular one, I think. And they tell a very talented host, and they do philosophy in sort of story form. And so I was a guest on there when they were talking about the proof paradox type cases and AI, uses of AI and predictive policing. And then I did a public philosophy event, and it stemmed out of through them, and it stemmed out of the public philosophy event meeting.
Okay, that's really interesting, because I feel like just personally, given that someone's put so much like time and research into like a field, like I feel that there couldn't be a better person to go to ask questions about legal changes, right? Given that like there is so much research being done on like what it means to kind of do, or like what it means to be in a legal field and have those questions being asked, right? Like it's like going to the expert kind of in the scenario where it's like normally you'd think like the expert is like the lawyer, right? Because they're the ones who are representing the people in battle. But no, in like when you're talking about kind of legal changes for what's needed in the case, the expert really is a person doing that research, which would be, legal epistemologists. So I think like that's kind of cool. Maybe like hopefully in the future there's like some sort of looking at you guys, like, just to ask questions about that, because I think those changes could be really, really, really important and crucial, right?
Yeah, and I think you're really stumbling. I mean, raising this really difficult question about interdisciplinary work and applied work, which is a question of access, which is itself an epistemology issue, is an epistemic difficulty. How do you know who to talk to? My own work is extremely interdisciplinary because I'm looking at statistics and social science and the psychology of trauma and queer studies. And so it's really hard, and linguistics. And so it's really hard to know who I can ask to inform my research. But then once my research is sort of ready to be useful to people, how do I get it out there? Like, how do people know that I'm working on these, writing a book about she said, he said cases and writing papers about the effects of the Me Too movement? And I think that's a really difficult epistemic question about how do we sort of find each other? How do people hook up in these kind of intellectual, if I'm just in philosophy, I know how to contact the people in philosophy, but how do I contact, say, the lawmakers, and how do they know how to contact me? And I think that's a really important service that public philosophy, so things like this Debbie podcast that you're running, can do, is to help people that wouldn't otherwise know about each other learn about each other.
Yeah, I definitely agree. Public philosophy is kind of like is really, really crucial, especially like I think at a youth level, which is kind of why this podcast exists in the first place. But I think there's a lot of cool work that's being done, but the access is definitely like an important feature in like how do we get that research out to the right people so that there can be actual changes, because at the end of the day it would be really, really nice to see actual changes reflected into like the legal system, because that's what hurts or harms so many people, and at the end of the day you kind of want to help those people, given that we have so much research in this field. But yeah, I mean, I kind of want to move on now kind of to your paper. You've written a paper called Legal Burdens of Proof and Statistical Evidence, and you kind of discuss this golden thread of criminal justice systems. What is that golden thread, and how is it how is it used? I think that golden thread is constantly heard in many shows, but like how do we use that in the court of law everywhere, I guess?
Yeah, the golden thread. So innocent until proven guilty, the presumption of innocence. Yes. And so this is this idea that sort of citizens and residents and compatriots, we sort of, and formally our government is treating us as if we haven't committed the crime, as if we're innocent, unless the state proves otherwise. So in criminal cases, it's always the state against the individual. In civil cases, it can be two citizens or two individuals, two residents against each other. And so there's this really deep asymmetry there where that comes out of that. So a whole bunch of stuff sort of flows from that. So one is this asymmetry. The state has to prove that the defendant is guilty to that legal standard of proof. The defendant doesn't have to prove that they're innocent. So they don't have a burden of proof. The burden of proof is on the state. There are some little kind of, sub-questions that the burden of proof can then fall to the defendant. So if they're saying like an insanity defense, then the burden of proof to prove that defense is on the defendant. The state doesn't have to prove that they're not insane. They have to prove that they are insane. But for the actual, did they commit the crime? So did they commit all the elements of the crime? The state has to prove it, and the defendant doesn't have to prove that they did not. They just have to defend themselves against the sort of case from the state. And so then some other rights sort of flow from this, so like rights to have representation, for example, but also the right to wear a suit in court as opposed to be wearing a kind of prison jumpsuit to sort of look guilty. In some cases, some of these, and also the right to not be incarcerated before you're found guilty, and or before you're tried, before you're charged. And so some of these rights, in practice, perhaps they're not entirely respected. So for example, the perp walk is an American invention, really. It doesn't have to exist. The perp walk is when somebody's been arrested, often somebody high profile, and they are walked from the prison cell that they're being held to the courthouse, where then they're going to formally, as a sort of matter of the institutional formality, going to hear their charge. The perp walk happens outside so that the newspapers can take photographs, so that it can go in the some more newspapers with the person sort of with their hands sort of handcuffed behind their back and police escorting them. And you're probably quite familiar with those images. That itself is a piece of theatre. It's a piece of theatre that's devised by the police and the prosecutors working together because they're on the same sort of side. They want to have more, to find more people guilty. But the perp walk doesn't have to exist. I mean, they could instead go in a vehicle, or they could go underground between the buildings, which, because they're very often hooked up, those cells in these courthouses, of course. Or it could be sort of done at a time when the journalists aren't waiting around, right? How the journalists know when the perp is going to be walking. So perp walk is a kind of piece of theatre. And it seems like it's not strictly speaking incompatible with this golden thread of presumption of innocence, but it's intentionally making the person look guilty. And then, so a lot of these sort of rights, there may be sort of in practice that's sort of disrespected in certain respects. Another really important part of this is the Blackstone Ratio, which is a separate kind of principle, but it's this idea that it's better that 10 guilty men go free than that one innocent man suffer. And people would sort of say different numbers and give different justifications, but it's this basic idea that incarcerating or finding an innocent person guilty or punishing an innocent person, there's something really bad about that. And it would be better if the person, the sort of people who actually did in fact commit the crime, they go free, that's better than having somebody who's in fact innocent be punished or incarcerated. That's the Blackstone Ratio. And that Blackstone Ratio helps explain why the legal standard of proof is so high. So beyond reasonable doubt is really high. It's not just sort of like 60% likelihood or something like that. It's really high. And the thought is because there'd be something really bad about having somebody who's innocent they met the standard of proof. The standard of proof was like, yeah, that evidence was pretty good. If that's all it took, if that's all it takes, you'd have more innocent people in prison.
Okay, definitely. That makes sense. I think we all have first seen those photos, but also like we all know the golden thread and how that's kind of used as like, even in like classrooms, even like teachers will even repeat that, saying like you're innocent until proven guilty in terms of like doing something bad, right? In terms of cheating, right? They always have like this concept that you're innocent and I won't believe anything, kind of coming like at a fair level, like no biases or anything like that coming in. And I think that's important. And I think like the Blackstone Ratio also is kind of important. It definitely makes sense. I think there's probably a huge debate about it, but like, I think it does make sense in theory, but I could also see why it wouldn't make sense as well. But yeah, I think like that golden thread is kind of a golden thread for a reason. So like it makes sense, but I'm actually kind of curious, on further along in your paper, you say that these legal standards of proof cannot be properly interpreted in quantitative terms. So why is that the case necessarily, and what exactly is a competing proposal for a non-quantitative epistemic condition on satisfying legal burdens of proof? And then also, if can explain kind of the difference between quantitative terms and non-quantitative terms in this area.
Yeah, sure, good. So yeah, maths is very powerful, and I think that power has a kind of seductive allure. So what I mean by that is, if you can quantify the thing, you can do maths on it. If you can do maths on it, you can do a lot. But the problem is, what if you shouldn't be quantifying it? So you see this in ethics with value, moral value. If you can quantify moral value, well, hey ho, you can get all kinds of principles, because now you've got this thing that you can do maths on. And so a lot of versions of utilitarianism and consequentialism is this idea that we have moral value is something like units of pleasure, and then disvalue is units of pain. And it's units and it's quantifiable. And so now we can like do maths on it. So like giving 3 people 10 units of pleasure is worth 30. And that's better than giving 2 people 5 units of pleasure, which is only worth 10. And so it's better to do this act A than act B. The problem is, or can moral value be quantified? And so you have a similar question arising in various areas of epistemology, non-legal epistemology, just epistemic value in general, and also legal epistemology, legal standards of proof. So can what legal standards of proof are be quantified? And in general, I'm very suspicious of quantification, and that's why I call it the seductive allure, because I think that if don't quantify the unquantifiable. if something can be quantified, great. Like, I do statistical inference, like I work on the foundations of statistical inference, and I have this background in maths and physics. It's like, if you can quantify it, great. The problem is that you might not be able to quantify it. And so people like to gloss these legal standards of proof as these kind of numerical values, as I was saying earlier, 50% for preponderance of the evidence, really high, like 90, 95% for beyond reasonable doubt, and in the middle there, 70, 75% for clear and convincing evidence. But I'm very suspicious that they can be given this quantificational analysis. And one reason is the proof paradox type cases I was mentioning earlier. So the gate crasher case with the music venue, and the taxi case that I quickly glossed. And you have the prison yard case where, say there's 100 prisoners in a yard and 99 of them riot and injure a guard, and then one refuses to riot and stands with their back against the wall. And if there's like CCTV footage, so security camera footage, you can pick up that 99 of them were rioting and one wasn't. But it can't tell which one was the one that refused to riot. So on that evidence, could you find them beyond reasonable doubt guilty? So could you find them criminally guilty for any particular individual? And I argue no. So one reason is, well, what if you then did it, if you iterated that? So you did it for if you repeated that. So for for this arbitrary prisoner who was there, you find them guilty. For this arbitrary prisoner who was there, you find them guilty. Eventually you'll find 100 out of 100 of them guilty, but you know that one of them was innocent. So you know that you found one person who is guilty, is innocent, you found them guilty. But if the legal standards of proof is a number, then it's lower than 99%, because 99% is very high. And so it means you have satisfied that legal standard of proof. And it just seems implausible that that kind of evidence is meeting beyond reasonable doubt. And another kind of reason that I think numbers can't capture everything that there is to say about evidence and legal standards of proof relates to corroboration that I was talking about earlier. So corroborating evidence is supporting evidence. So evidence that supports something that you already have evidence for. So some kind of confirmation. So you already have some evidence for P and you get some more evidence for P, that's corroborating evidence. And I think one reason for thinking that this can't be captured, that legal standards of proof and the epistemic value of corroborating evidence can't be captured by numbers, is you can have evidence like that DNA evidence, not the one with the twins, ignore the twins one, just DNA evidence, can make it really, really, really probable that the person, say, committed the burglary. Really, really, really high with DNA evidence. And now suppose you also get the person, suppose that the burglary was stole a watch, and somebody says, oh, I caught being a fence, like selling on the stolen goods, and says, oh yeah, it was Jim. Jim sold me the watch. And then Jim was the one who was sort of caught with the cold hit DNA evidence. Well, that second piece of evidence is extremely powerful because now you have all this DNA evidence and you have this other person, this informant. It means that, well, now you're really sure that it was Jim. But there wasn't enough space on the number line to explain why that second piece of evidence was so powerful. Because you were already like 0.9999999%, 0.99999 confident that he did it. But you get this second piece of evidence. There's just not enough space between 0.99999 and 1 to capture or to explain or to sort of vindicate. Now the difference when you've received that second piece of evidence of just how much more confident you are that Jim did it. So that's kind of some of my reasons for suspicion about the quantificational analysis. So what are the alternatives? So qualitative analysis, like non-quantificational analysis. My own account of legal standards of proof is based on ruling out relevant alternatives. So again, that's taking this theory in epistemology, the relevant alternatives theory of knowledge, and then taking all those insights and all that apparatus and applying it to the legal case. So I say, what people wanted to say about knowledge being the state of, we've ruled out all the relevant alternatives, all the things, all the other error possibilities. I haven't said what that means. So take that infrastructure, that apparatus, that framework, that is what, whether or not that is what models knowledge, that's what models legal standards of proof. And it's kind of in the name. Beyond all reasonable doubt is like, have you ruled out all of the reasonable alternatives? And I say that what it is to be a reasonable alternative is not a matter of quantification. It's something else. So I haven't really said what it is. I've just said that I give an alternative model for it. So I'm not sure if that was very satisfying.
No, it definitely makes sense. I mean, to an extent, makes sense. I mean, like, it's kind of like, I understand this concept that like there are non-quantifiable things. Like the example that you gave, like within like the number line, there's no space between 0.99999 and 1. And I was, I am also kind of like I like math a lot, so like I also try to reduce things to math whenever I have the ability to. And so in my mind, while you were like narrating the example, I was like, okay, so like I'm pretty confident right now. And then you gave the second example, and I'm like, okay, I'm like really, really confident now, but like I don't know what the distinction is between those two, right? And so like I guess it makes sense to need a qualitative account or like some sort of theory that is able to account for that. And although it's just not looking at the quantitative, I mean there wasn't like the most detailed explanation of it, but I think that is at least an important question to like explore. Maybe like I don't know how the research is on that, but maybe if there's even like a lot of different qualitative explorations, then I guess that's really interesting. I kind of want to move on towards like the end. You have like two more questions, but there has been a lot of controversy recently, between some pretty important trials, and we talked about this a little bit earlier about juries, but ever since the Cal Rittenhouse case, where he was acquitted of 5 original charges, there has been like a lot of questions about how juries are kind of hailed as the democratic components of the system, but also maybe that are biased in some sort of ways. Are those questions ever entangled with epistemology? And are like questions of the epistemology of juries, and bias, are those like all epistemological questions? And is there exploration in your field of the importance of juries, etc.?
Yeah, definitely there is, for sure. Lots of questions. So many questions are raised about juries. It's a big, rich topic. So, for example, you say with jury of your peers, and now during the kind of the selection of the jurors, then the lawyers might say, well, so suppose it's, say, a sexual violence case. The jurors might say, well, has anyone here been a victim of sexual violence? And the people that put their hands up, they can be struck from the jury pool, leaving now people that haven't been victims of sexual violence, or at least people who don't say that they have. Well, so now it's a selection effect. So what is it about the jury of the jury of your peers that means that if it's a case of sexual violence, then the perpetrator or the alleged perpetrator, the person on trial, is sort of having all the victims struck as not peers, for example. So those kinds of questions. And you have this with capital cases, cases where the one potential punishment is capital punishment, execution by the state. One of the very first questions they'll ask is, well, could you find the person guilty given that one of the potential punishments is capital punishment? And now anyone who would be a conscious objector to that, I say, well, I couldn't do that, they're going to be struck. Well, so now if you have a capital case, it's not a sort of arbitrary selected set of people in the jury pool. The only ones left are the people who are okay with, not just okay with capital punishment existing, but being people who could say, yes, I could find them guilty. Now, I'm not saying what the solution to these problems should be, but that's at least some questions that are raised. So how does that affect the jury pool? But when we're looking at that, and there's lots of biases of the juries, and there's issues about the jurors just not being able to follow the complexities of, say, DNA evidence, for example. But we always have to ask, well, what's the alternative? Because we can see these problems in philosophy when it's very abstract. We can just look at the problems and say, well, there are all these problems. But now when we're looking at policy, there's always this question, well, what are we going to do? What should the alternative be? And so are juries better than judges? Are juries better than computers? I mean, computers can't do something like this, but are juries better than randomizing devices? And so, and there might be the better than doesn't necessarily just have to mean more likely to get it right. There's also these other values of jurors and disvalues of jurors. So one is giving a sense of public trust in the system and sort of being invested in the system. So a randomizing device, I mean, people just wouldn't respect it. Sort of, even if it managed to be more reliable, it was a weighted randomizing device or something, so it was more reliable than jurors. I'm not sure, then there would be this sort of a problem with trust in the system if people used it. But also jurors can have these other values, like aspirational, about what kind of society do we want to have. So the idea that we are living together as citizens, as residents of a nation. And so one of the duties that we have and one of the rights that we have is being tried by a jury of our peers and being eligible to sit on a jury. It might help people cultivate certain kinds of virtues, and it might sort of embody a certain kind of message of, well, you're not just merely a consumer or merely a worker, you are in fact a citizen, and that comes with these certain duties. And so we expect you to be sort of educated in certain ways, for example, and that it's part of what it is to be living together. And sometimes when juries seem to have the wrong result, a result where people go, how can this possibly be? Sometimes it's actually that the laws are the problem, not the jurors, or what was the evidence was presented at the court, or how the lawyers performed. And so a case where the laws might be a problem is, you see this with, say, for example, grand juries, when their police have used lethal force against, say, unarmed suspects in attempts to arrest, where maybe the suspect was fleeing or something like that. And then there'll be a grand jury saying, which will be a case saying, well, is there a case that can now go to court? And the grand jury will say no. And then people will say, how can this be? Obviously the police killed this person. The evidence is there. It's been recorded. This jury, what are they thinking? And the answer is often, well, the jury got it right. The problem, if there is one, and I think there is the laws, which is that the police are allowed to use lethal force in a lot of cases where they probably shouldn't be.
That's definitely interesting. I mean, I think there's like a lot of philosophy to explore, kind of in just understanding like the concept of juries and like different alternatives for it. I mean, you're really right. Like, what is the alternative? I mean, honestly, I've just like kind of briefly looked at it given the current events that are kind of happening around America, but I haven't, given a thought, obviously, to kind of exploring my own like theory of like what could be an alternative. But yeah, definitely there are other problems that could also arise. Like, I don't think it's just like the juries. I think it's an intersection of kind of a lot of different concepts coming together, being shown through juries. And kind of like that's where you can kind of understand maybe like the impact of race or the impact of appearance. All of those things as well play a really big role in juries. So I think it's kind of like it's an interesting feature or interesting area, given that like a lot of different concepts come together and you can kind of explore how that works in a public audience that's kind of like filtered or randomized in some sort of way, right? So I think it's like kind of cool to see that and kind of cool to explore like the different specifics, but also like just general top understanding of how juries work. So yeah, that's like really cool, and I'm glad like there's some philosophy there, because I'm definitely gonna want to read up on that. But to wrap up this podcast episode, I wanted to ask you how students who are interested in taking maybe law in their future, or even activism to a certain extent, can utilize legal epistemology to help them in their future. What are some benefits that students can gain, whether they be in high school or maybe even like grad students or college students, by learning more about legal epistemology and kind of just the field of epistemology in general? How can that help them in their future?
Yeah, great. Well, I think it's good question. So in general, I think learning philosophy is learning how to think well. And there's other ways to learn how to think well too, but philosophy is really good for just like thinking well. Like, give me your reasons and I'll give you some counter reasons, and we'll figure out the best reasons, and we'll figure out sort of what we should think. So it's really good at honing those cognitive skills. And epistemology is a study of how to think well. And so it's particularly effective, especially as we're going through this epistemic crisis of fake news and conspiracy theories, epistemic bubbles. So on social media, people just hearing sort of what they already believe because they filtered their friends according to these epistemic tribes, these epistemic communities. That's the epistemic bubbles. So there's all kinds of epistemic problems going on at the moment. So epistemology is a really good thing to study to better understand those, partly so people aren't victims of conspiracy theories and epistemic bubbles and gaslighting and so on. And sort of vaccine hesitancy and so on. And so it can be good to help people think more clearly about topics, but then also the next stage is going ahead and making a difference. And so there are all these really applied relevant topics where students could be writing op-eds and in things in their student newspapers and local magazines and opinion pieces about, for example, the Rittenhouse trial, and really using that clear thinking that they've learned and then helping other people understand the issues. And again, you have these feedback loops. And so by doing that, by engaging publicly, by having these kind of public debates, including in, for example, op-eds and student newspapers, people can better understand. And so you get these nice cycles of understanding better. The other thing is for people that want to go to law school, like this could be a really important, this could be like a really valuable way to sort of enhance an application to law school, but then also something to be working on in law school, especially if a part of what you have to do in law school is some boring kind of rote stuff that you just have to learn to pass the course. This could be a really nice way to also be doing philosophical engagement. So as you're learning, oh, what is the evidence law? You could also be thinking about, well, what justifies, if anything, the evidence law? Which parts of the evidence law are good or bad? And that's legal epistemology. And so, yeah, if you're people for going into policy, going into law, also going into things like social work and crime and research, it's so interdisciplinary. So I think legal epistemology is really good for these reasons.
That's awesome. If you are, in any, like anyone who are like maybe a student or anyone applying to law school, definitely look into legal epistemology then. And also like writing blogs or just kind of like op-eds on like what you personally think. I think reflectiveness in like the hyperpolarized state of America right now is really, really necessary and, just really good to kind of find your own voice. So I want to thank you so much, Dr. Gardiner, for your time today. I really learned a lot, and I'm sure the audience did as well. And there's a lot of cool questions that anyone can learn or like, I guess, ask from just listening to this podcast. So thanks so much for your time today.
Well, thank you so much, Saurish. I really appreciate it. I really enjoyed this, and thanks so much for the opportunity.